Today, we're going to explore 3 critical estate planning mistakes, how you can easily make them, and how much they can cost you and your loved ones. And we're also going to talk about how you can avoid them. Let me ask you, does any of this sound like you? Well, maybe you're worried that your family will be left with a mess after you're gone, or maybe you've worked hard to leave an inheritance for your kids, but now you're concerned they could lose it to a divorce, a lawsuit like a car accident, or even wasteful spending habits. Or maybe you're afraid of overlooking something or making a legal mistake that could hurt your family and cost them grief and expense. If any of those scenarios sound like something you're worried about, I have some good news. None of those things are the real problem. They're just symptoms. The real problem is that you haven't shifted your thinking about estate planning. So for right now, just know this. I have the solution to the real problem. But first, let's jump into the 3 critical estate planning mistakes that you might relate to. Mistake number 1, dying without a will. Let me ask you a question. Do you have a will? If you do, great. Now, if you don't, you're in good company. According to a recent survey, 63% don't have a will at all. And you might think, well, that's just a problem mainly with young people who don't have many assets. Well, the same survey found an alarming 50% of seniors over age 65 don't have a will at all, or if they do, it's not up to date. So what's the big deal if you don't have a will? Well, your family then gets introduced to the government, who will say who gets what. This is very stressful for your family. But how stressful? Well, let me tell you about the tragic story of Doreen. She was a 71-year-old widow. She had 2 adult children, Ben and Alicia. They were very close. Now, Doreen, she owned land that she inherited from her parents, and it was important to her that the land stay in the family, just as her parents wanted. So one day, she sat the kids down and asked them to promise to keep the land in the family. They promised, and she felt a certain peace that her legacy was preserved. Well, then Doreen developed pancreatic cancer stage 4, and the prognosis was not good. In her final days, she got the kids together and reminded them about the family land. They promised to carry out her wish. Unfortunately, nobody bothered to put the promise in writing. No one thought about getting a will to make it legal. And then Doreen died a few weeks later. Now, shortly after the funeral, Ben and Alicia turned their attention to Mom's stuff. They remembered the promise they made to her. Well, then they were surprised to learn that things would not go smoothly or quickly. They found out they had to go to court. They had to open up a probate of their mom's estate. Why, they asked? Well, because Mom didn't have a will. They didn't know this. Nobody told them about the importance of having a will. So one of the first things that had to take place was the appointment of an executor by the probate judge. Well, it sounds simple enough, right? Either Ben or Alicia would do it. Here's where the trouble started. They couldn't agree on who, and they each thought they could do it better than the other. Well, after some wrangling, the judge appointed Alicia as the executor, and he knew better than to appoint both together because, after all, they were fighting. Well, this set Ben off. He refused to cooperate with his sister. It was a long 12 months going through the probate process. They also learned probate's very expensive, $23,000 later in lawyer fees. Now, towards the end of the probate, Alicia sent her brother some legal papers to sign so they could become joint owners of the land because they were 50-50. Well, guess how Ben reacted? He refused to sign the papers. He told his sister he wanted the land sold to get money. Alicia reminded her brother about her mom's wish to keep the land in the family, and Ben said, "Sis, I don't care." This was Ben's way of getting back at Alicia. Well, their mom's wish wasn't in writing. It wasn't in a will, so too bad. Alicia was crushed. Imagine Doreen's sadness looking down on her kids. So what was Doreen's mistake? Well, dying without a will. And what was the cost of her mistake? Well, the $23,000 in lawyer fees for the probate. But what about the land having to be sold? It wasn't in the family any longer for future generations. How do you put a price tag on that? You can't. And what about Ben and Alicia, the kids who were so close growing up, who now don't talk to each other. How do you put a price tag on that? Doreen's mistake cost more than just money, and it's a cost, frankly, that can't be quantified, that's going to be felt for generations. Now, mistake number 2, not protecting a child's inheritance. Do you ever wonder what will happen to your kid's inheritance after you pass away? Do you want it to last for your child? Do you want to give them a legacy, not only to remember you by, but one that will still be around in retirement when they can really use it? Well, I'd like to tell you about Phyllis, who unfortunately did not take steps to protect the kids' inheritance. She was a 76-year-old widow with 2 adult kids, Kathy and Jim. Phyllis loved them more than anything, and she'd do anything for them. Kathy, she was the oldest child. She was married for 27 years. When she and her husband were in their mid-40s, the marriage started to crumble, and Kathy would confide in her mom that the marriage was in trouble. But Phyllis kept pretending the problem really wasn't there. And her other child, Jim, he liked to drink a lot. Over time, his drinking got worse. One day, he got behind the wheel and got a DUI. Luckily, he didn't hurt anyone, at least this time. Naturally, Phyllis was devastated. Deep down, she knew Jim had a problem, but every time she thought about it, she just convinced herself it was okay, that somehow things would get better. She'd always tell herself, oh, but Jim is such a good boy. I tell you, a mother's blind, unconditional love. Now, Phyllis became a widow about 6 years earlier after being married to Roger for 47 years. And Roger, he liked things simple. When they were much younger, they went to a local lawyer to get their wills done. It was Roger's idea. Simple wills, just as Roger liked it. The kids would get everything 50-50. They didn't think it important to protect the kids' inheritance. Again, very simple. Now, Phyllis started to let things slip, including updating her estate plan. And a lot had changed in the years since she and Roger had done their simple wills, including their daughter ending up in a troubled marriage and their son developing a drinking problem. Well, Phyllis then died from a stroke she never recovered from, and her kids were devastated. Kathy's marriage got worse, and Jim started to drink even more. Now, under Phyllis's simple will, everything went to the kids equally. Phyllis's total assets were worth about $700,000. So after expenses, each kid was expected to get $330,000. Maybe this inheritance would relieve the stress of Kathy's troubled marriage and help Jim get back on his feet. Unfortunately, that didn't turn out to be the case. 2 very tragic things happened. Almost as soon as the inheritance check was written to Kathy, her husband filed for divorce. And about 6 months later, Jim went on a bender and got his second DUI. This time, it was a bad one. He killed a 27-year-old young mother. So guess what happened next? Phyllis's dream of giving a nice nest egg to her kids, of passing on a legacy they could remember her by, was shattered. Half of Kathy's inheritance went to her ex-husband, and all of Jim's inheritance went to the lawsuit. And to add insult to injury, Phyllis's estate had to go through the probate court before the inheritance checks could be written. The lawyer got a fat $21,000 fee. Phyllis's mistake was not to update her will. If she had met with an estate planning lawyer, she would have understood how each child's inheritance was at serious risk of being lost given their situation in life. She would have learned about solutions to protect their inheritance. So did Phyllis's mistake come at a cost? Well, you bet it did. If you add together half of Kathy's inheritance lost in the divorce and all of Jim's to the lawsuit and the fee paid to the lawyer, the total cost of Phyllis's mistake was $516,000. And the saddest part was that this mistake could have been avoided at a fraction of the cost. Do you think Phyllis could have done better? And then mistake number 3, not getting qualified legal help. I've heard it said that there are 2 sets of rules in life, one for the informed and one for the uninformed. Well, for many people, the concept of estate planning sounds good, but they have little knowledge of how to develop a workable plan to meet their needs. And this may describe you. You may know you need to do something, but you're not sure where to start or how to go about it. And you certainly don't want to repeat the costly mistakes you've just heard about. Working with qualified legal help is the key to getting this done and done right. Working with an experienced estate planning attorney will enable you to solve your unique problems and develop a plan that works for you. I find some people pretend they're not going to die, or they've got plenty of time. Some people believe, well, they won't become incapacitated or need someone else to help them with financial and healthcare decisions. Some people sort of hope everything will just magically work out. And a lot of people procrastinate and do nothing. And some people, even worse yet, dabble with a do-it-yourself or online will program. Look, I know it's hard to think about your mortality, but don't be a victim of one of these costly mistakes. Don't be a statistic. Now, let me tell you the choice you have and how we can help. The way I look at it, you have a choice. You can think about it. I call this the 90-day plan to nowhere. 90 days later, you'll be no further along to solving your problems than you are now. You might want to call this the 90-day plan to nowhere. You'll end up doing nothing, which will end up leaving a burden on you and your family. Or you can do something absolutely amazing for your loved ones, taking action. Turn to an experienced estate planning attorney like myself. I do this work because I've seen far too many families get stuck with a mess after their loved one dies. I've seen the stress it causes in fractured families. I do this work because I've seen a child's inheritance completely wasted away in short order, whether because they had a hole in their pocket or they got divorced or sued. The family legacy vanishes. And it's sad because it's so preventable. Look, estate planning is complex. This is our main focus area. We help people alleviate their worries and achieve the peace of mind that comes with finishing the race strong. So how can we help? My team and I have set aside time to speak to you personally about your situation and possible solutions. Whatever your biggest challenges, we've seen them and we can help you overcome them. You'll book a free 15-minute phone call with our team to evaluate your situation. And during this call, we'll make sure we get clear on 3 things. Number 1, where you are now. Number 2, where you want to be. And number 3, whether it makes sense for us to start working together. So if you're ready to create a lasting legacy for your family, go ahead and book a free 15-minute phone call with us. Just click on the button below this video and you'll be taken to our booking page. When you get there, you'll see our calendar page with all the available appointment times. Just grab whichever one works for you. Then, once you answer a few short questions, we will get on the call with you at the appointment time you select. I promise it will be the best time you'll ever spend thinking about your family's future. And oh, by the way, you'll also receive a free offer for booking the call. So go now to book your call, and we look forward to speaking with you very soon.